Hello. Welcome to my office. I'm Muhammad Aiman, partner here. So can I know what I can help you today?
I have a bit of problem. I have this land and there is no way to get across my neighbor's land to get to the main road. It is causing me a headache.
Okay.
Look at here.
Okay. So I understand it's not uncommon for this situation to arise. So from this situation, in my perspective, I think that it's something that called land administrator's right of way, which is in the short term we call LIA2005. So I think it might help.
Garo?
Yeah.
What's that? Can you explain more?
Okay, absolutely. So imagine your land is here and your neighbor's land is next to yours. So LIA2005 is like a path that allows you to cross their property legally. So basically, it's a way to balance the rights of landowners while ensuring necessary access.
I see. So that would mean I will not be prevented from entering their land lah.
Yes. So LIA2005 becomes a legal road that can be established to solve access issues like yours.
I see. Okay.
So now let's break down the concept of LIA2005 from the video that my associate prepared.
Hi there, Zulkarnain here, and today we are diving into the topic of land administrators' right of way, or we call it LIA2005. So, what is exactly LIA2005? Well, imagine having the legal right to stroll through someone else's backyard without actually owning the place. That is called the right of way. According to the wise words of Lee Hoon-ho, Chief Justice, a right of way may be described as a right of passing over someone else's property. The right carries with it no interest whatsoever in the soil of the land, which remains the property of the owner. Now, let's break down LIA2005 into its divisions: public right of way and private right of way. The public right of way, as defined in Section 389, subsection 4 of the National Land Code, provides a legal avenue for the public to travel a specified area of land to access a public terminal. A public terminal, as stipulated in Section 387 of the National Land Code, encompasses areas such as the foreshore, river, railway station, or a public road. This right is solely for the purpose of access, and it allows members of the public to travel the specified area regardless of whether they own or occupy nearby land. Examining the precedent set by the case of Cik Bik binti Mota and Pentadbir Tanah Kuala Krai, we understand that the principle of inviolateness of land can yield to the higher interest of the public under specific circumstances. In the presence of an urgent public necessity and the absence of an alternative road, the land administrator may grant a public right of way. In regards to a private right of way, in the National Land Code, where the essence of private right of way is prescribed in sections 389 subsection 2 and subsection 3, it defines the avenues for pass and repass between reserved land or forest and a public terminal, or to facilitate the removal of rock material from any land. Last but not least, we shall discuss the creation of LIA2005. For a private right of way, adherence to statutory procedures is paramount. The land administrator grants such rights through endorsement, with memorials entered on both the land register and the title document. In contrast with a public right of way, they can be established by dedication to common law or by statute. Here's a crucial point to mention, however: the creation of a right of way may interfere with or reduce the rights of the owner of the servient land, the land over which the right of way is established. Referring to the legal precedent, Tong Tiong Lim and Pentadbir Tanah Daerah, Johor Bahru and another, it is important to note that the proprietor of the land has no say in the grant of the right. However, the proprietor of the servient land does have the right to object or seek reopening of an inquiry. In navigating the creation of LIA2005, understanding these procedures and legal doctrines is important. So thank you for joining me on this exploration of the complexities of LIA2005.
Hello everyone. For this section, I'm going to emphasize and break down the salient feature of the LIA for a clearer understanding. Picture this scenario: a private land standing between you and the LRT station. Like the one right behind me, there are no other alternative routes, a direct route that would significantly benefit the public. LARO steps in to make this happen, as described under Section 389, subsection 2 of the National Land Code, either as public or private right-of-way. This concept ties back to the doctrine we've touched upon earlier. Solus populi suprema lex. The welfare of the people is the supreme law. However, this is not an absolute rule. Its application depends on the land administrator's discretion, which brings us to our next important feature. The land administrator wields the authority to decide if the situation is expedient, weighing the agency of public interest. This isn't just about convenience, it's about urgent necessity. Take, for instance, the creation of a path from a private land to this LRT station. The land administrator ensures that public access is not just a luxury, but a pressing need. This expediency becomes a critical consideration in the making of LARO. The land administrator carefully evaluates each situation, determining if public interest demands immediate action. As such, let's conclude this section of the video.
Expediency? What's that?
Okay, to explain it to you, I refer to a case I have had before, whereby the main road leading to a school poses safety concerns for the children.
What? Isn't that quite risky for them? Are there no other risks that they can take?
Basically there is, but after that the passageway goes through the neighbor's properties.
Oh, so then what are the legalities of the neighbor's property?
Okay, regarding that, the people there might be able to apply for the grant of a public right-of-way, though we need a show it's not just convenient, but an urgent necessity. So basically, the law defines expedient as a necessary and urgent, which means the main road situation must meet this criteria. So the law requires proving no alternative road is reasonably available.
Oh, so what would be considered in applying for the right of way?
Okay. In that case, I will need to present the high risk of the main road, so the necessity for the alternative road, and ensure we meet the legal standards for the expedient access. So to do so, I have done a simulation of the school surroundings. Let me show you.
Hello everyone, thank you for joining me today. I'm here to shed light on a crucial situation in Putrajaya, which is in a scenario that calls for an expedient solution. Let me walk you through the urgent need for a LIA. So as you can see in this video, the main roads in Putrajaya are bustling with the traffic, which is a heavy traffic. Unfortunately, this is the only way for students to reach their schools. So, with the lack of proper infrastructure, such as sidewalks, poses a serious risk for their safety. The main road is not well established with sidewalks, making it hazardous for students who have no choice but to use this road. There is significant probability of an accident, and we need to address this issue promptly. So now, let me introduce you to a solution, which is the LIA. So this alternative route located between neighborhood houses provided a much safer pathway for students to commute to the school. It is a dedicated pedestrian lane that minimizes the risk of an accident compared to the current main route. As you can see, the LIA is a well-defined pathway that prioritizes the safety of our students. It offers a much-needed alternative to the main route, which lacks the necessary infrastructure for the safe pedestrian travel.
I do understand the situation better now, but I still have a very vague idea on what is expedient.
Okay, in that case, I will continue showing you the video again.
Good evening once again, ladies and gentlemen. My name is Haris Niza. Now, let's delve further into the aspect of expediency for the LIA. The land administrator, as we have discussed before, holds a crucial role in deciding whether it is expedient to create a LIA. First and foremost, what is the term expedient? It means more than mere convenience or pleasure. It refers to a necessary and urgent necessity for access.
Okay, so I have to clarify that this is not an unqualified way to grant the LIA. This is further subject to a test to determine expediency. So this video will explain further on.
Okay.
Let me continue.
Alright.
Tak apalah, daripada dah kita sembang ni, saya rasa saya ada disclaimer lain untuk. Okay, terima kasih. To get back into this topic and to explore further, I think we shall revisit the case of C. Russell. In this case, the judge emphasized that there must be something more than a mere convenience, a situation of actual gravity and urgent necessity. Despite C. Russell not being landlocked and having an alternative route to a Port Dickson Beach, the collector granted the right of way anyway. The judge questioned the expediency of the right of way and held that the right of way should not have been given in this case. Moving forward, let's discuss the validity and reasons for granting the land road. In the case of Liu Peklian and the conservator of forests, the court emphasized that the collector must be satisfied that access is not otherwise reasonably available. Reasonably here doesn't mean conveniently. Reasonably in this case means that the access to the land should not be available in a manner that is practical, feasible, or justifiable, considering all relevant circumstances in this case. It emphasizes a standard beyond mere convenience and requires a careful evaluation by the collector before a granting of right of way.
Okay, so if we want to apply a right of way, it has to be expedient. But how about when it is inexpedient?
Okay, I will show you. Now imagine someone wants to build a big road right through your beautiful garden. So it is not so big. In the case like this, narrow might not be the best idea because you want to protect your special space.
Oh, I see. So it's about weighing pros and cons.
Yes.
Good day everyone, I am Safia and today we're delving into a crucial aspect of Malaysian land law, specifically the inexpediency of land administration right-of-way (LARO). Our exploration is grounded in legal precedents, and to kick things off, let's examine a landmark case that highlights the judiciary's stance on this matter. In the case Tong Tiong Lim and Pentadbiran Tanah Daerah Johor Bahru, the court refused to grant leave for LARO. Why? The collector cancelled the right-of-way order because the appellant had an alternative access route to his land. Simply put, the court deemed it unnecessary as the appellant had another viable way to reach his property. Now let's examine LIA2005's case. Here the defendant sought LARO over the plaintiff's land because it was closer and more convenient, especially after the closure of the second right-of-way. The court, however, held that the land administrator must consider existing alternative routes. Granting LARO when another option exists is deemed a wrongful exercise of discretion. Last but not least, in Kelab Kerenang, Pulau Pinang and Pentadbiran Tanah Daerah Timur Laut, Pulau Pinang, the word landlocked is interpreted as fully or almost enclosed by land. In the present case, the engineering report tendered by the second respondent had stated that there was an existing access path to the lot 418 from the public road via lot 417, except that the path was not tarred and impassable to motor vehicles. It is settled law that where there was an alternative right-of-way, the land administrator should take that fact into consideration. In these cases, inexpediency essentially means that if there's already a safe and viable alternative route, there is no urgent necessity for a land administration right-of-way. It's like saying, hey, I know there's a good road, but can I use yours as a shortcut even if it's not as good? The law in these cases usually says, no, stick to the better route if you already have access to. The law says that asking for a special shortcut to someone's backyard just because it's a short doesn't show expedient. Well, I hope you guys will understand better. Thank you and do wait for my next video. Bye!
Okay, so after going through the details of the LARO, what do you think about this?
It's a lot to absorb, but I can see how it provides a structured way to address my issue with my neighbors.
Okay, let me show you something. Okay, that's the essence of it. LARO ensures a balance of land ownership and necessary access. So now let's revisit your situation first. Okay, so you need the access to the main road and currently there's no alternative path than going through your neighbor's land. Okay, so otherwise it is considered as a landlock, correct?
I guess so. So how do we start?
Okay, we can begin by gathering the necessary details about your land and the access problem you are facing and determine if there is any urgent necessity. Okay, we can demonstrate to you that we might have a strong case to apply
Private right of way.
Okay, once we submit the application to the land administrator, we'll consider the application. And if they agree it's expedient and necessary, they will issue an order for the creation of the right of way.
Oh, so there is a solution for my problem. Thank you for explaining everything so clearly to me. I feel confident and informed to moving forward.
Okay, so it's my pleasure. I will be here to guide you through every details and every stages on your issues. So if you have any question along the way, don't hesitate to reach out to me.
Alright, thank you for having me out.